Justice Leonen.
Good afternoon, Counsel.
Good afternoon.
Good afternoon, Counsel. Let me just look at the relief that you are praying for in terms of the petition that you are representing or the petitioners that you are representing. What, in effect, is the relief that you're asking?
We're simply asking for prohibition to prevent the implementation of RA 10354 in the arm.
Not to declare the law as unconstitutional or illegal because it affects the arm.
We are simply saying that the arm has its own RH law pursuant to its political autonomy. So our petition is limited in scope. It is not within the function. It is not within the purposes of the petitioner to. And we leave it to the other petitioners to question the constitutionality of RA 10354 per se. But ours is simply as applied to arm.
So, in theory, your own petition can be separated from the rest because the grounds that you're raising is completely different. Is that not correct?
Technically, I was surprised why I was included in the oral arguments.
Oh, so you were as surprised as your petitioners. Also, may I ask, has there been relief in the arm regarding an incident or a situation relating to this?
Well, Your Honor, the RH law was passed, the arm RH law was passed in December of 2012. Its implementing rules have not yet been finalized by the Secretary of Health of the
So
DOH.
you filed your petition prior to the issuance of the implementing rules and regulations?
We filed this petition simply because the RA 10354 is very all-encompassing.
No, Counsel, I'm looking at the timing of your
Yes, we
your
timed
filing.
it. In other words, we did not wait.
You
we
did not
wait for any we did not wait for any memorandum from Secretary Ona to be passed on. We did not wait for any incident. In short, we jumped the gun simply because we saw the law on its face.
By jumping the gun, can we say that this is premature?
Well, Your Honor, we are aware of that argument, but we maintain that the law itself, on its face, as applied, is all-encompassing.
There
is no need for
the position of the ARMM on your petition.
The position of the ARM is that they believe that their arm version will stand.
I mean, are they petitioners in this case?
No, they're not.
Have you implemented them as respondents?
No, Your Honor.
So how are we supposed to know the official position of the ARMM in this case?
Well, ours simply our
In other
position.
words, Counsel, shouldn't they have been implemented in this action?
Your Honor, as far as the petitioner is concerned, regardless of his personal views on reproductive health, as an advocate for regional autonomy, he is prepared to fight tooth and nail to protect any law passed by the arm.
Yeah, I understand that. But the question is, shouldn't the ARMM have been implemented as an indispensable party to your petition?
We submit no, Your Honor.
Why?
We submit that the law itself, that is all-encompassing and including all local governments, regardless of where situated, to comply with RA 10354, is on its face already violative of the autonomy granted to the arm. That is the position adopted by petitioner. We did not feel that we had to wait for a specific instance when the Secretary Ona would direct.
No, Counsel, my question was not relating to whether there's an actual controversy. We've traversed that already. You stated your position on that. The question really is whether the arm should have been implemented as an indispensable party, and you say that no, because...
Well, it's not indispensable in the sense that the court can pronounce judgment even without their presence.
What about the interpretation of their MMA 280 and 292? Are we sure that their interpretation in terms of implementation will be or must be the same as ours?
Well, that's why, Your Honor,
because you said that in terms of some of the provisions, there is advertence to the Darul Ifta. Is that not correct?
Yes, Your Honor.
And the Darul Ifta is not this court, correct?
Yes, Your Honor.
By the way, what is the Darul Ifta?
It's like their Council of Elders, their House of Opinion.
No, I'm sorry, I don't think that there is a Council of Elders.
Well, it is a collegial body, of Islamic scholars and Muslim leaders who give Islamic rulings on certain social, political, family, and other matters.
Yes, on Islamic law. Is that not correct?
Yes, Your Honor.
And they issue a fatwa. Is that not right?
Yes, Your Honor.
What is a fatwa?
It's their Islamic ruling.
an Islamic ruling, or is it an opinion of the Islamic scholars who are respected in the area?
Well, that I would concede to your version, Your Honor.
Yes, and because it is a bit complicated as to know what a valid fatwa is, insofar as we are concerned, then therefore I think that the ARMM should have been implemented. Is that not correct? By the way, what is a valid fatwa in terms of Sharia?
Well, Your Honor, as I was made to understand, particularly in this case, in 2004 there was a fatwa issued with regard to reproductive health. It was issued in
No, I'm just asking about the validity of a fatwa. Let's go through it part by part,
Okay.
so that we are able to understand it and understand the question as to whether the arm should have been implemented as an indispensable party. What is a valid fatwa, counsel? Since you raised it in your
Yes.
oral arguments.
Well, to our mind, to our understanding, a valid fatwa would be one that was issued by the collegial body in terms of a specific issue being raised.
Of course, the fact that it is consensual and the broader the ulama and the mufti that are involved, the better for the strength of that fatwa.
Yes, Your Honor.
But can you tell us if there is a hierarchy of norms that will tend to show whether a fatwa is valid or not?
I'm not qualified on that matter, Your Honor.
Yes, precisely. Again, shouldn't the arm have been implemented as a party to this case so as to clarify whether the interpretation of this court, or perhaps your interpretation as petitioners, would be the same as that of the arm and that of national law is not a problem, but with the MMAA, which does, as you said, provide in its provisions the consultation with the Darul Ifta?
Well, Your Honor, it is when we filed this petition, it is our position that there was no need to implead the arm as a party, as an indispensable party. It was our position that simply based on the law, RA 10354, based on the Constitution, based on RA 9054, that it was sufficient that petitioner, as a constituent of the arm, would be able
You
to
argue
upstand
the
it.
autonomy of the arm, is that not correct?
Yes, Your Honor.
And part of the autonomy of the arm is that it has a distinctive cultural, historical characteristic. Is that not correct?
Yes, Your Honor.
Shouldn't the court respect that by allowing the arm to also plead in cases like this and not arrogate simply upon itself its interpretation of things like Darul Ifta, Fatwa, Mufti, and all of this?
Well, Your Honor, if the court were to invite...
For instance, counsel, you mentioned 2 years of lactation. This is in what fatwa?
Well, this was given. Well, this was based on my communications with the author of the RH bill.
The
In
author
other words,
of the RH bill.
when I talked with Assemblywoman Arin Tila regarding what contraceptives would be,
Can you explain to us the context of 2 years of lactation, which is part of the Quran, of course, and, into the interpretation of the Grand Mufti and the fatwa issued in 2003 as well as the one issued in 2012?
Well, Your Honor, I will be first to admit that I am not an expert on that.
But you did mention 2 years
Yes, I
of
mentioned it
lactation.
precisely because in my discussions with the Assemblywoman Tila, he explained to us that precisely contraceptives that affect the lactation of a mother within 2 years is not acceptable to them because it prejudices the child.
You mean, counsel, we are speaking for them, but we do not know what their Sharia is? In terms of the question that I'm asking now, which you raised in your oral arguments, do you want us to speculate and therefore do a disservice for the peoples that are represented?
Well, Your Honor,
Again, shouldn't we have implemented the arm?
Your Honor, without trying to be argumentative, as we mentioned our position, and we have no objection if this court were to invite as an amicus curiae.
As a
the
matter
regional
of
government.
fact, in terms of the fatwa issued in 2003, I think it was read by the Grand Mufti himself, Sheikh Pasigan, in Davao, correct?
Yes.
That they said that contraception was all right. Isn't that correct?
Yes, Your Honor.
Yes. And then it was again succeeded by another fatwa in 2012 upon the request of the DOH. Again, they said that it was all right to have concepts like reproductive health and family planning. Is that not correct?
Yes, Your Honor.
And it is not entirely accurate that in Islam, that artificial contraception is prohibited. Is that not correct?
Your Honor, we never said it was. In fact, as you mentioned, the
In your
2000...
oral argument, you said that the bias is towards natural family planning. Is that
Well, I
not
am just
correct?
reading the first guiding principle.
So-
they were in MMA 292.
Yes,
And it
but
does
also in
recognize...
MMA 292, there is also advertence for purposes of certifying which contraceptives are legal, not only the FDA, but also the Darul Ifta. Is that not correct?
Yes, Your Honor.
And of course, the Darul Ifta includes the fatwa. Is that
Yes,
not
Your
correct?
Honor.
Yes. And therefore, it is not true that it is only natural contraception which is allowed, correct?
Your Honor, I never said it was the only one. As I
Okay.
mentioned in our oral
By the
arguments.
way, would you know the basis in terms of the fatwa? The basis in the hadith or in the Quran of
No,
why contraception is there?
Well, as I understood it, they mentioned that they said that there's nothing in the Quran that prohibits contraception.
Yes, but that is not all. It was a very well-argued fatwa. It was deeply rooted not only in the Quran, but also in the hadith, and in fact in the Sunnah. Is that not correct?
Well, I am not in a position
Again,
to...
the question is, when we rule on this matter, shouldn't we first have the ARMM first have a ruling on this or an implementation before it goes up to the Supreme Court?
As far as the petitioner is concerned, again, that's to be repetitive. I'm sorry to be repetitive, given your position you've taken. When we filed this petition, it was the belief
I have
of...
not taken a position.
No, in
These are
terms of
just
your
questions. Yes.
statement, Your Honor, of which I'm supposed to respond
These are
to.
not statements, these are questions.
Your questions. Our position really, Your Honor, for the petitioner was that we felt it was sufficient, based on the law, based on the Constitution, to file this petition.
By the way, Counsel, your petitioners are
Altila and Professor Kashim.
females? Males.
Males.
Do you have a petitioner who is a woman, Muslim?
None, Your Honor. Just
None.
two male petitioners.
Just two.
Two.
To represent.
Well, they're representing their interests as constituents of the arm.
By the way, is it Islamic for only one person to represent the Ummah?
They're representing their own interests as citizens.
As citizens, okay.
As residents of ARM, because particularly for Petitioner Altila, who is an advocate for regional autonomy.
Yes. Yes, I know Petitioner Tila very well, and I know his contribution to the movement to gain autonomy for the area, and I highly respect that. But again, the petitioners were only two males. Is that not correct?
Yes, Your Honor.
Yes. Section 20 of Article 10, do you have a copy of that?
Of the RA 10354.
No, of the Constitution.
I'm sorry.
Section 20 of the Constitution.
Yes, Your Honor.
Can you please read the chapeau or the opening paragraph?
Wait, Your Honor. Wait, Your Honor. Let me just... Okay, here. Wait, I'm so... Oh, wait.
Within its territorial jurisdiction.
Yes, Your Honor.
Yes.
Where is that?
Within its territorial jurisdiction and subject to the provisions of this Constitution
Yes, sir.
and national laws, the Organic Act of Autonomous Regions shall provide for legislative powers over. I'm just curious, Counsel, what your interpretation is of that, the importance of that phrase, subject to the provisions of this Constitution and national laws.
Our interpretation is that the arm operates within the confines of the Constitution. It is not beyond the Constitution. Definitely, and even in fact, Section 17 says that anything which is not granted to the arm under this Constitution or by law is reserved to the national government. So I read this in connection with RA 9054. This section, together with RA 9054, which says at night, under RA 9054, the arm has legislative powers over matters except the following.
I'm sorry, but in the Constitution, the enumeration is positive. Is that not correct?
Yes.
It enumerates the areas where the autonomous region, whatever its name is going to be, is going to have powers over.
Yes, Your Honor.
But the Organic Act has a different kind of enumeration. Is that not correct?
Negative.
It's a negative enumeration. Which shall govern?
I think, Your Honor, both. You have to look at it both you have to combine. First, of course, the Constitution is there.
If there is a contradiction, which governs?
Of course, the Constitution.
Constitution. As a matter of fact, Section 20 says so, that subject to the Constitution. Is that not
Yes,
true?
Your Honor.
But it also says it does not stop there. Subject to the Constitution. It does say subject to the provisions of this Constitution and national laws.
But
What does that mean?
Well, you have to, in other words, when it says it's subject to national laws on areas that are not covered by the devolved powers, because also the Constitution provides that what is devolved to the arm is also those which are enumerated in Section 20, as well as that which may be allowed by law, which is RA 9054.
Is RH law a national law?
Well, it is.
Yes.
It is applied to all.
MMAA 290 and 280, are these national law?
It's an arm law.
It's an arm law. Therefore, is it national law?
292 is a...
Subject to the provisions of this Constitution and national law, the Organic Act of the Autonomous Region shall provide for legislative powers over. So the MMAAs on gender equality, gender and development, as well as reproductive health, produced by the ARM Regional Assembly, are an exercise of the legislative power of the Autonomous Region. Is that not
Yes, Your
correct?
Honor.
Can that trump national law?
Your Honor, it is our position, presenting from the discussion of this court in Keda versus Senate as well as in prior decisions, that the Congress is restricted from passing national legislation laws for implementation in the arm
If
on
the
subject
Organic
matter.
Act provides a big power, such as that they can pass matters relating to personal, family, and property relations, that broad,
Yes.
okay, can the Regional Assembly pass a particular law that may be inconsistent with a national law? What is your position on that?
Our position, so long as it doesn't violate the Constitution, yes, it can.
Can you cover in your memoranda, just to abbreviate this interpellation, exactly what is meant by Section 20, the first, the opening paragraph, subject to the provisions of this Constitution and national laws?
Yes, Your Honor.
As you may suspect, this justice is very much interested in the kind of argument that you are going to put up in relation to this particular provision. But let me just complete this interpellation by looking at Section 1 of Article 10. You have that. There is a first sentence to Article 10, Section 1. It says, the territorial and political subdivisions of the Republic of the Philippines, and they enumerate provinces, cities, municipalities, and barangays. So it means only the provinces, cities, municipalities, and barangays are territorial and political subdivisions of the Republic of the Philippines, correct? It goes to a second sentence. It creates a new body, which is, there shall be autonomous regions in Muslim Mindanao and the Cordilleras as herein provided. Is that not correct?
Yes, Your Honor.
Yes. As a matter of fact, Article 10 is divided into three parts, right? One, the first is general provisions. Then there are provisions on local governments themselves, and then there is a separate provision on autonomous entities, such as, for instance, Section 15 down to Section 21. Is that not correct?
Yes, Your Honor.
Does this matter in terms of the structure of our Constitution?
We are mindful that the title of the provision talks of local governments. That is a starting point. It considers everything under the title as local governments. But precisely the separate provision for autonomous region provides it in a different standing than other local governments. And precisely in the numerous decisions of the court, it has recognized the different standing of autonomous regions, regions possessing political autonomy, separate from what is granted to local governments, which they define as simply decentralization of power.
Okay. That is all, Chief.